Hi everyone, this is the first of two webinars dealing with data security for attorneys. In this webinar, I'm going to try to just give a little bit of context to the topic and provide an introduction. And in the next webinar, I'm going to talk about some specific data security tools that attorneys can use. So just the basics with data security. We're talking about protecting the confidentiality, integrity, and availability of information. So we're not just talking about keeping information private, but we're talking about preventing it from being tampered with and also making sure we can always access it. Attorneys do have a duty to protect information, and as we'll see, this comes from several different sources. Like many other duties in the law, reasonableness is the standard of care. And we'll look at the different sources to see kind of what this reasonableness means in the context of data security. And finally, with this topic, I think it's important to know your limitations. Again, we're not expected to be IT experts by any means, but we are expected to know what we don't know and know when we need to seek outside help with things like network security or encryption, that sort of thing. So first of all, what is reasonable security? Well, I think it's fact specific, and it's definitely much more about a process than any sort of specific measure you need to take. As we know, if someone really wants to get at your data, they probably can. So as attorneys, we're more concerned with being able to demonstrate that we have a process in place to prevent a breach. In addition to satisfying our duty, having this process in place should prevent most forms of identity theft. Again, if the NSA or some huge hacking group wants to get at your data, they probably can, but just your run-of-the-mill identity thief type things, these processes should prevent that. A typical process, some of the things you want to think about are identifying your information assets, conducting periodic assessments to see would people want to get this data? What are our major risks? Developing and implementing a program, and then making sure everyone's trained on it and complying with it. Monitoring the success of the program, and then reviewing, making adjustments as needed. So what is the source of our duty to protect data? Well, I think there's three different places it comes from. One is statutes and regulations. We'll look at a few examples. The ethics rules and opinions, both the ABA opinions that they put out as well as the specific state jurisdiction opinions and rules. And then finally, industry standards. Certain types of businesses or attorneys that practice in certain areas have unique standards that they have to comply with. So first of all, statutes and regulations. Right now, 48 states and DC have some sort of security breach notification law in place. Essentially, they require you to let someone know if their personal information has been compromised. 21 states have data disposal laws. Essentially, you're not able to just throw sensitive information in the garbage without taking some sort of precautionary measures. Just as an example, Indiana's law reads, a person who disposes of the unencrypted, unredacted personal information of a customer without shredding, incinerating, mutilating, erasing, or otherwise rendering information illegible or unusable commits a Class C infraction. The law does bump it up to a Class A infraction if the person violates this section by disposing of the unencrypted, unredacted personal information of more than 100 customers. 13 states have some sort of law in place requiring security for personal information, and only 6 states at this point, but I believe more, will start enacting laws requiring businesses to actually encrypt personal information that's being transmitted out of their own secure network. But I think for us who aren't in one of these jurisdictions that has one of these laws, it's still really important to know encryption technology, know how to encrypt information. The duty also comes from the rules of professional conduct and the ethics opinions. We've looked at this rule before, Model 1.1 on competence, comment 6. To maintain the requisite knowledge and skill, lawyers should keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology. As we've seen, more and more states are starting to adopt this comment, and I think data security clearly falls within this rule. Model Rule 1.6, confidentiality. Section C is another one. A lawyer shall make reasonable efforts to prevent the inadvertent or unauthorized disclosure of information relating to the representation of a client. Comment 18 lists some specific factors to consider, and it reads, factors to be considered in determining the reasonableness of the lawyer's efforts include, but are not limited to, the sensitivity of the information, the likelihood of disclosure if additional safeguards are not employed, the cost of employing additional safeguards, the difficulty of implementing the safeguards, and the extent to which the safeguards adversely affect the lawyer's ability to represent clients, for example, by making a device or important piece of software excessively difficult to use. It also says a client may require the lawyer to implement special security measures not required by this rule, or may give informed consent to forego security measures that would otherwise be required with this rule. We also have Rule 5.3, responsibilities regarding non-lawyer assistance, Section A, with respect to a non-lawyer employed or retained partner and a lawyer who individually or together with other lawyers possesses comparable managerial authority shall make reasonable efforts to ensure that the firm has in effect measures giving reasonable assurance that the person's conduct is compatible with the professional obligations of the lawyer. So this would be, for example, using a cloud storage company, making sure that, because ultimately it's going to fall back on you as an attorney. So you need to make sure that their data is secure as well. We also have the ABA and State Bar ethics opinions, and this is just a sampling. There's many more, but talking about things like protecting the confidentiality of email, considerations for hiring a cloud provider, electronic storage and access of files, and maintaining client file confidentiality. And there's many more examples, but all these things, again, emphasize reasonableness, which, again, kind of drives home the point. It's not so much fact-specific, or it is fact-specific. There's not a one-size-fits-all solution, but reasonableness is what we're really going for. And then the duty also does come from industry standards. I think we talked about this a little bit before, but there's the PCI data security standard. So this applies to businesses that accept credit card information. It also applies to law firms that represent credit card companies and have access to all these data, all these different types of data. And there's certain steps that you have to follow. Again, I won't read through them here, but there are things like maintaining a firewall, encrypting your network, keeping up-to-date security software. And as I mentioned before, there are actually companies out there that are PCI security standards certified that you can hire to make sure you have these 12 factors in place for your law firm. Just as an aside, we looked a little bit at the competency rule. It's interesting to think if at this point competent representation of a client requires talking with them about cybersecurity. At this point, I don't think it necessarily does, but I think it depends on what your practice area is. You know, even though we're not IT professionals, if we do a lot of work, say for small businesses, helping them get set up, I think you would need to let them know about laws relating to secure disposal of personal information, things like the PCI data security standard, and again, maybe even if you don't fully understand it, at least telling them about it, maybe recommending outside IT help for them, that sort of thing. So just to give some context again to this discussion, I think right now is a really unique time for this topic. I think that overall, organized groups are using sophisticated tools to try to access law firms' data. This is both identity thieves, hackers, but also state actors, whether we're talking about China or the NSA. I think it's also with the onset of bring your own device to work and outsourcing, there's really unprecedented risk right now of data breaches and information exposure. Never before have employees been freely, taking to work, leaving work with confidential information like they are now on smartphones and tablets and that sort of thing. And then also, speaking specifically about the NSA, there has been some discussion about that. A couple months ago, the New York Times reported that Australia's version of the NSA had intercepted and offered to share with the NSA information relating to an American law firm's representation of Indonesia in trade talks. This created obviously quite a stir within the legal community, and the ABA's president wrote to the NSA for clarification. The NSA issued a response that it has afforded and will continue to afford appropriate protection to privileged attorney-client communications acquired during its lawful foreign intelligence mission in accordance with privacy procedures required by Congress, approved by the Attorney General, and as appropriate, reviewed by FISA. So it clearly, wasn't denying the report, but it seemed to indicate that at this point the NSA is going to continue to make efforts to respect the attorney-client privilege. But it is another thing to think about that, storing data in the cloud, things like that. The NSA likely does have access to it. So what's attractive about law firm data? Well, I think there's a couple things. First of all, law firms tend to have personal information, credit card numbers, names, addresses, social security numbers. They also tend to have privileged information on those accused of crimes or those involved in business dealings. And then I think also a lot of times law firms, especially those that do a lot of corporate work, are really like an easy access point into corporate information. Typically, big corporations are going to have better security than the law firms that represent them, so hackers will view firms as an easy access point to obtaining that information. How do data breaches occur? Well, there's all sorts of different ways, anything from totally innocent accidents to more malicious actions. These are some examples, and I'll attach the slides as well. All these links work and you can read the stories. But some common ways: improper disposal of personal information. This first example, an attorney died, and when they were cleaning out his office, rather than shredding or incinerating all his files, they just threw them in the trash, and eventually all his files ended up at this recycling center, and there were medical records and phone numbers, addresses, criminal histories, things like that. So that can happen. Devices with unencrypted data are stolen or lost. This is an example. There was a Maryland law firm that was representing a doctor in a malpractice action, and one of the attorneys was taking the light rail home in Baltimore and left their computer. I don't know if they left their computer on the train or if it got stolen, but the hard drive wasn't encrypted, so whoever found it had access to patient histories and insurance information. In this case, the firm was actually trying to do a good thing. They had this person take the computer with them, thinking that, well, if the office burns down or there's a flood or something, at least we'll have all the information stored in an external spot. But they forgot to encrypt the computer, so this was a huge problem. Security patches not being installed. I'll show you a program you can use to see if any of your programs are missing security updates, but I know this is something I'm guilty of too, but failing to install updates is a big issue. Social engineering scams. I know we've probably all gotten those emails before asking you to click a link to verify your information, or saying that you're due this huge inheritance, but you just need to provide some information. Well, this happens sometimes at law firms. This example was where an attorney got an email saying this banking transaction had failed, and they needed to click the link. So they did, and it installed spyware on their computer and was able to log their keystrokes and get their banking password. And before you knew it, like $336,000 had been transferred from the law firm's account to somewhere over in Russia. So this story actually talks about the law firm and the bank were involved in litigation. The law firm was saying, the bank shouldn't have honored the transfer. So social engineering is a big problem. Phishing, malicious insiders. This is an example of someone who worked for a law firm got fired, and they had some friends that were interested in hacking, so they were able to give them access to the law firm's server, and they installed spyware and were able to obtain some information. And the sixth example is just another example of someone downloading something off the internet with spyware, and it was able to log a bunch of personal information. So these are some interesting stories, and there's all kinds of examples out on the internet you can read about. So this was a basic introduction to data security. In the next webinar, I'm going to go through some specific tips and tricks you can use to hopefully protect your information. Thanks.